Supreme Court today. Now, the court has set the next date of hearing on the 10th of August. But we need to understand what this case is, which is in front of the court, who are the petitioners, and what the court said today. So to help us with that, we have Bhadra Sinha, who tracks the courts for us in this episode of Government Matters. So do start sending in your questions. Bhadra, so first let's talk about, what are these petitions that are in front of the court, and who are the petitioners?
So Ruhi, there are 9 petitions that have been filed in the Supreme Court with regard to the Pegasus snooping scandal. And most of the petitioners are primarily journalists. We have eminent journalist Mr. N. Ram, who is one of the lead petitioners. Then the Editors Guild of India is also one of the lead petitioners. Besides that, we have individual journalists whose names allegedly figures in the list of potential targets.
Right.
So all of them have filed individual petitions, but the grounds raised in all the petitions are more or less common. They talk about infringement of their privacy, they talk about violation of their fundamental rights, and they also talk about the fact that if the alleged snooping has happened, then it has happened in violation of the rules, in violation of the settled law. And the demand that has been raised by these petitioners basically is to to direct the government to produce the contracts, if any, signed with the company that provides the spyware or the software, and also direct the government to present the list of the so-called names or the figure or the people who were on the target list. So these are the petitions and these are the prayers that have been made, and today arguments were heard at length by a bench led by Chief Justice of India, Justice N.V. Ramanna. I won't say that the arguments got concluded today. They continue to be inconclusive, and as you said, the hearing will continue on August 10th.
So what did the court say today?
Okay, so Ruhi, there is no formal notice issued to the centre, although the petitioners had asked for it. They kept praying for it. But the court made certain oral observations and said that, before it issues notice to the centre, it would like to hear the government, to the central government. But it did not really clarify on what does it really want to hear. But yes, it did make a pertinent observation to the effect that it said that, multiple petitions have been filed, and it has in some way led to some confusion, because some petitions have actually challenged the vires of the IT Act,
right,
the Information Technology Act. So before going ahead with the decision to issue notice, and before deciding that on which petitions notice should be issued, the bench says that it wants to hear the government. So there is no formal notice issued, but yes, it wants the government to be present on 10th August. That is the next date of hearing, with some sort of response, not maybe a complete or a full response, but some sort of stand.
Right. All right, Bhadra, so can we talk a little bit more about the grounds of the petitions, and the kind of precedents we have in the past in terms of judgments?
Yeah, see, Ruhi, the primary concern that has been raised by the petitioners, by all the petitioners, is that the alleged snooping is a violation of the fundamental right to privacy. Now, as we all know, the term privacy was expanded after the 2018 judgment came in the Puttaswamy case. As per the Information Technology Act, privacy only deals with bodily privacy. It doesn't really talk about privacy such as digital autonomy. But the 2018 judgment expanded the term. Now, privacy, the judgment said, permeates in Part 3 of the Constitution, which actually deals with our fundamental rights.
Right.
Now, once that has been laid down by the Supreme Court, then privacy is a very broad concept. And according to the petitioners, this snooping or this sort of surveillance, it kind of infiltrates my life, and it tends to keep a track of my movements, what I eat, what I do, who I talk to, who I meet, and this is a very serious infringement of my right to privacy, which I am authorized to have as per the Constitution of India and interpreted by the Supreme Court. So this is actually the main argument. Besides that, what the petitioners are saying is that even though surveillance has to take place, see, we all know that our fundamental rights are subject to certain restrictions, and there are judgments in the past that have actually clearly stated that as well. But those restrictions can only be imposed, subject to certain conditions. What the petitioners are saying is that even if the snooping has taken place, it hasn't taken place subject to the rules. Now the rules require, a committee to be set up. There has to be proper deliberation on why you need to, carry out surveillance.
Right.
And usually surveillance is carried out, in cases of crime or in cases of terror activities. And that is exactly what the company which supposedly supplies or sells the software has also said internationally, that this software is bought and used by the government in cases of crime and terror. So now what these petitioners are saying is that if this software is used for this purpose, then why people like journalists or activists or people working in courts, why were they,
Or politicians.
why were they potential targets? So these are the reasons why they have filed the petition, and they want the government to come out clean with it if the government is involved in the surveillance or the snooping.
Right. This question is from Tanveer Panjwani. What grounds do you think the government is going to take in the next hearing, or what are the various grounds the government can take as per your professional opinion? So what are experts saying?
We all know the stand taken by the government, even if before the matter has gone to the court. The government has time and again refuted the fact that there was surveillance ever. But from my experience, from what I have heard, is that I don't see the government taking a ground on the first day of the hearing. They would take some sort of time, or they may be forced to make a statement before the court to say that we are looking into the matter and that the court should not interfere in it, because after all it's an executive decision, if at all it was taken. So it is possible that the government, of course the government is going to oppose the petition, and they would try to stall judicial intervention in this matter. It is definitely going to be the stand of the government.
All right. Okay, this is a question from Shrijan Sumant, who is a new member of the Prince YouTube community. How can a consensus among common people be built with regards to privacy rights? So privacy is such an ambiguous, amorphous concept.
No, yes, you're right. And the 2018 judgment actually lays down the contours, I must say, the broad guidelines of what privacy is and how it should not be violated, and if at all it can be, then what are the restrictions. It all differs from case to case. And I think this case would also be decided accordingly, So, but yes, the broad guidelines laid down in the 2018 judgment are very clear, that privacy is something which is my fundamental right, and it cannot be violated at any cost.
Right.
But and if the government wants to infringe upon it, then it has to, the law which they come up, it has to be done through a legislation. First of all, it has to be done through a legislation. And that legislation should also, it has to be tested on the doctrine of proportionality to see that how proportionate the law is, whether that law is actually achieving the objective for which it has been promulgated or not.
Right.
So, the guidelines have been laid down, but yes, it is up to the court, each court, to decide on case-to-case basis whether there is violation or not. So, Supreme Court usually in such matters, after laying down the guidelines, tests each and every case individually on individual parameters. So this case will also be tested accordingly, like any other case.
Right.
So once the rules are set, once the rules are laid down, then it's up to the courts, up to the particular court to decide whether a particular action by the government really amounts to infringement or not.
All right. Okay. This is a question from Dev Verma, who's also a member of the Print YouTube community. The SC says allegations are serious. If the media is to be believed, which sounds to be a diplomatic statement, what can the Supreme Court really do if the government is found guilty?
See, I think it's too early to say that if the government is found guilty. But today's observation by the court, I would just like to repeat, were based on the arguments made by the petitioners.
Right.
And at the outset itself, the bench had said that the allegations appear to be serious if true. But at the same time, the bench was very categorical in making a statement that all these allegations have been made on the basis of media reports. But it did not doubt the veracity of the media reports. In fact, it said so. But what it wanted to ask the petitioners was for some more material, for some more verifiable material. Because usually, you know, I'm not saying that the media reports are doubted, but courts usually prefer to have something extra, something more than what is written in news reports, and then decide whether a matter requires investigation or not. So as far as my understanding goes, you can't really say that the government will be found guilty, because it's going to be a long drawn process.
Right.
The court may or may not set up an SIT, that is a special task force to look into the issue. So it's very early to say that the government is guilty or not.
All right, then Veer Panjwani, don't you think that the government will have to take a stand about whether they used or did not use Pegasus? Can the SC ask this question, direct question to the government? So I think that's at the heart of the matter.
That's right. Yes, of course, the government will have to take a stand. I'm not saying that they will not. And definitely the Supreme Court can ask the government whether there was a contract between the central government and the company, because the petitioners, the arguments made by the petitioners talks about this only. In fact, they cited a California court proceeding to highlight this aspect, that this company enters into an agreement only with government agencies. So this software is not sold to any private individual. So, and if the snooping has happened in the country, and if the number of the names that figure in the list, if all this is true, then the government has to come out with a stand, either to deny it or to accept it. And if they accept it, then they will have to produce the agreement which they have signed with the company. There is no doubt about it.
Yeah. Right. Okay, this is a question from Runa Sharma. What are the various options before the Supreme Court in terms of proceeding with the matter?
See, as of today, the court chose not to issue a formal notice. So on the next date of hearing, we will have to see the stand of the government, and it is possible that the Supreme Court issues a formal notice, and once that happens, then a proper and a regular course of hearing will start, because then the government will respond to the allegations made by the petitioner. The petitioners will be given a chance to counter the allegations, and then a proper hearing will take place inside the courtroom. And I mean, if the court is really serious about wrapping up the proceedings, then it should do it quickly, as soon as possible. So this is how the matter will proceed in the court.
Right. So Bhadra, we've often seen that in such cases, it opens up in a way a Pandora's box, like we saw in the case of Aadhaar. Privacy became the big argument. Yes. So what does this case lend itself to? Are there other similar cases that can be opened up, or similar issues that can perhaps the court might need to
Ruhi, look into? I think in this particular case also, privacy will be the primary issue, because and as we all know, we've been talking about data privacy, and data privacy is becoming a very big debatable topic. So this case could lead to that how safe and secure my data is, because phones for all of us is very integral to our daily life. Right. And this entire snooping incident is happening through the phone. So whether our lives are private or they are not, that is something which will actually be determined in this particular case, because that is exactly what was argued today, that what the spyware and the software does, it actually tracks my minute-to-minute movement. So it really sounds very eerie also, that I am being under surveillance, and somebody is kind of keeping a look at me. So the core issue in this entire case would be about our lives, about our private lives. So that is why the lawyers for the petitioners kept emphasizing about the fact that this is not about an individual case. It is in the interest of the nation, in the interest of the citizens of the country. It is about their privacy, and it also concerns about our security, because after all, it just shows that how vulnerable we are.
Right.
So the entire case is going to revolve around the issue of our privacy and of particularly data privacy.
Right. Well, as Bhadra pointed out, with the issue of data privacy at its very core, at its very heart, the Supreme Court is now all set to hear the Pegasus matter. We know how it has rocked Parliament. We know how it's hit headlines for the last couple of weeks, but now the matter is in court, and hopefully it would lead to some kind of logical conclusion. Thank you for watching Government Matters and for sending in your questions. Keep subscribing to our YouTube channel. Do become a member of our YouTube community. There is a link given in the description box below which has all the details.